welcome to the 29th episode of Business Litigation TV. I'm your host, Jesse David Eisenberg, and I am a New York business litigation attorney. This episode is going to be all about discovery. People know usually how to start a case. If someone's a complaint, it's pretty simple. You get someone served. And people know what happens at the end of a case. You go to trial. It's the middle portion that people really aren't that familiar with, and that phase is called discovery. And really what it is it's a bunch of people, let me rephrase it, it's the attorneys getting together, exchanging information in preparation of trial or just in furtherance of the case. Some terms, just to help you out, are a bill of particulars. A bill of particulars is basically when one side asks the other for more definite statements as to what they're suing for. The defendant can also give a bill of particulars as to its affirmative defenses and to its counterclaims, so then the plaintiff would know how they're going to defend themselves. There's the document demands, where you say, I want documents for any correspondence between this state and this state, that between the parties, something like that. Anything, any contracts, any leases, any pertinent information, you're going to ask for that. A big one is the deposition. Each side has a chance to get deposed. That's where you sit down with the attorneys and a court reporter and you ask questions. And it's kind of like a pre-run for trial. That's what I tell my clients. You get a sense of how is this person as a witness? How is this person, going to answer this question or that question? And that way you get a formal, transcript of what they said in case they change their story later. And again, so you know how they're going to respond at trial, or at least have a good idea. You also exchange, who's going to be a witness, who's going to be an expert witness. Experts, again, if you've been following me, they're very important to prove certain elements, what damage was done on a car, what something is worth. There's certain times you absolutely need an expert, and then you exchange who your expert is going to be. And then, in various cases you exchange maybe an accident report, a police report, a medical report, things like that. And then when it comes time, if someone doesn't answer, you do have to make a motion to compel them to make an answer. And if someone doesn't follow that, if they don't answer, then you can actually have your entire case become irrelevant. So let's say you're the plaintiff and you don't answer. Well, then they'll dismiss the complaint if it's really egregious. Or if you're the defendant, they'll dismiss the answer and you'll have no defense to what the plaintiff is saying. And then, it also, and the biggest point is it helps you assess your case and the case of what the other side has. And that can a lot of times lead to settlements. If you have the case where everybody is, let's just say the plaintiff can prove without a doubt. He fell on someone's property, it was that person's fault, there's no defense. Well, that's going to lead to a settlement if discovery can't come up with any defenses, basically, for the defendant. And then lastly, something that's important to know is, this isn't Perry Mason, okay? And again, I know it's a really old reference, way older than even I am. But there's usually not an aha moment at trial because everything has been exchanged. And that's kind of the point. This isn't a poker game. Or if it's a poker game, it's a game where everybody sees all the cards before you bet. So it's supposed to be a very transparent interaction, and at the end of the day, it's just whoever has the strongest hand usually ends up winning. All right, so I hope that helps explain what the middle phase is, the discovery phase. And if you have questions, if I wasn't clear about something, please feel free to email me at Jesse, Jesse, at jdelaw.nyc. All right, thanks again, guys, for stopping by, and until next time, take care.